Okay. Good morning, everyone.
Good morning.
Good morning. I hope everyone's well. Check in now. A lot of you haven't. Please do so. Again, we had about 20 people absent last class, and I hope that number decreases. I had about the same level of absenteeism in my other class. So again, the school is here. If you need anything, please don't hesitate to come and talk to us. And again, I'm only taking attendance so we get a track of where our students are. For this week and next, I'll excuse any absences under the circumstances. Just so you know, Isaac, who she sits right there, he's a lieutenant in the HPD, so he's working his butt off around the clock. And so please give him a special thank you when he comes. Like, I know he's not in your section; he has a special schedule because he has his night shift, day shift stuff. So please thank him when he gets back. We'll turn this off. Got 20 absent today, but the same. All right. If you didn't, Mark, I'll get you later. I want to begin class today by asking a question that's similar to a question that I've asked you guys in the past. I'm not going to tell you what the question was, but I did ask you a very similar question before. And the question is this: a contract of sale and a deed are different. True? False. The contract of sale and the deed are different. True or false? So I'm going to let this keep running. Where did I wind up last week, or last class?
I think I'm first.
Oh, Mia, I appreciate your honesty. Thank you, ma'am. What'd you put, Mia?
I put true.
You said they're different. Okay, why'd you say true?
Because I feel like the contract for sale is just the contract where the buyer will pay the seller money for like the property, and the deed is more like handing over the bundle of sticks.
Ooh, bundle of sticks. Someone's remembering last semester. All right, tell me what do you think?
I put true, like it was different. Because a contract for sale can be less strict on what needs to be in it.
So you think, which do you think is longer, the deed or the contract of sale in terms of pages, right? You think the deed's longer. Okay. Lane, which would you?
I put true also. I said like the contract, well, here's my thinking. The contract is like the terms of the sale, and then the deed is like showing actual ownership.
Alright, did anyone put false? Okay, Bradley, you're more or less next, so I'll come back to you in a minute. Why'd you put false?
Well, the deed is shorter than the contract of sale.
So, you said they're not different.
No, I said they are different.
So then that's true.
Well, I don't get these questions. Let's go with, I think.
Did anyone think they're different? Do I think they're the same? Okay, yeah, well, why'd you say they're the same?
Because the deed in the chapter that we read, like both parties have to sign it, and the chapter is called contract of sale.
So you think they're the same thing?
Yeah.
Okay, anyone else put the same thing? All right. So, let's see what we got. Get results. Okay. Anna, it's not right, but it's a worthwhile exercise, right? Even the people who got this right didn't quite give me the right answer, so I want to explain this, right? Contracts of sale and deeds are different documents. Last week, way before we talked about the flood, we discussed contracts of sale. And do you remember how long those documents were? Right? I think Lane said the contract is shorter, or maybe it was Taylor, I can't remember. The contract of sale is a hell of a lot longer. Right? The contract of sale is a lot longer. It has all these provisions about lead paint, right, and fixtures, and all these different aspects. What are you going to do at utilities and prorating bills? Remember this? Does this sound familiar? Remember how long that contract of sale was? A contract of sale is exactly what it sounds like. It's a contract by lawyers that consider every conceivable aspect of the transaction, like 15 or 20 pages in length. All right? In contrast, the deed is like a couple paragraphs. You have one if you go to page 615 of your book. And please open your books up. That's not a request, but go to page 615 of your books. And you see what's called a general warranty deed. Ready? One paragraph, two paragraphs, 3 paragraphs. The entire thing's 3 paragraphs long. Okay? So there's a difference between a contract of sale and a deed. I don't want you to confuse them. Students, every semester in the exam, confuse the contract of sale and the deed. Don't confuse them. You know the difference. Right? The contract of sale is this long document with all these terms about utilities and furniture and refrigerators. The deed is a very simple document. It looks the same in almost every jurisdiction. I'll show you examples in a couple minutes from Texas. But it looks the same basically in every jurisdiction. And what it's basically saying is, I, the owner, am conveying to you, the buyer, title to this property. And with that title, I make certain promises. Okay? A synonym for a promise is a covenant. Not the covenant of Abraham, right? You know, the covenant, a promise. And we'll talk about these different types of covenants in a minute. But you have to remember one thing. Breaching the contract is totally separate from breaching the deed, right? Let's say you sell a house with lead paint and you put in your contract of sale, there was no lead paint. Easy example. You breached your contract, but you haven't breached the deed. Why? The deed says nothing about lead paint. It's not part of the deed. So when you're a real estate attorney and you're having some sort of dispute, you have to know what you're going to sue on. Are you going to sue on the contract of sale? Or are you going to sue on the deed itself? And depending what you sue on, the answers are different because the statute of limitations work in different fashions. We'll get there in the cases today. But you have to understand the contract of sale and the deed are not the same thing. They have different sorts of promises, different covenants in them. And depending what covenant was breached, you can sue on one or the other. But don't get confused. Okay? Everyone get that much, sir? Okay? Now, I'm going to ask another question that I think I asked earlier this semester. I'll change a little bit. The deed and title are different. True? False? That's your question. The deed and title are different. True or false? All right, Emma, I'm going to come back to you. What did you put? You said that they're different. Okay, why do you think the deed and title are different?
Well, the title is like what gives you actual ownership of the
And what's the deed?
The deed is kind of, like a symbol of conveying that title.
Yes, okay, good. Serena, what'd you answer?
I put A also because the deed is like the instrument for the title.
Oh, you guys remembered. Very good. Did anyone put B? Okay, good. I'll show the results maybe. Okay, a couple people put B. But I'll take 92%. I'll take that to the bank, right? That beats the curve. The answer is A, right? And I think I mentioned this a few weeks ago before the semester broke up. Deed and title are distinct concepts. They're not the same. The deed, right, is a piece of paper. It's an instrument, right? What does the word instrument? No, I don't mean like a clarinet or a saxophone. It's the piece of paper, the document that conveys the title, right? In order to convey title, you need to transmit a deed. The deed is what conveys the title. They're separate concepts. And again, the contract of sale doesn't convey title. Let me make that point one more time. The contract of sale, that long document, that isn't what conveys the title. What conveys the title is the deed. So we have these 3 concepts, right? Don't get them confused. You have the contract of sale, which we did before the break. we have a deed, which we're covering today in the next class, and then we have title, right? The contract of sale is this long document with all these promises. The deed is a document that conveys title with certain promises that are called covenants. Okay? Questions on that? Get your terminology straight. Even if you don't understand the difficult details, if you get your terminology straight, you're like halfway to a B, right? If you just give me the right words, and even if you don't get yourself the right bottom line, you're almost to a B. So just get your terminology straight, and I think you'll be happy. A lot of this class is getting nomenclature and terminology right. So get your words right. So I showed you on page 615 the example of a deed. This is what's called a general warranty deed. And generally there are three types of deeds. There are three types of deeds. There's the general warranty deed. There's what's called the special warranty deed. And there's what's called the quitclaim deed. You'll have to know all three of these terms. I called you. Philip, what is a general warranty deed?
General warranty just, I guess, trying to define it without using words, but it's a very kind of a broad, gives you basic, just basic default kind of promises about the property.
Well, Philip, let me ask you the question a little differently. Why would someone want a general warranty deed when they're buying a piece of property? What are they worried about?
Well, things like whether the person conveying the deed actually owns the property, and
what would we call that? Let's say a person is selling a piece of property they don't actually own. And again, I promise in the exam, someone will sell a piece of property they don't actually own. I promise you, 100%. 100%. Give me an example.
Oh, an example?
Yeah, what's problematic about someone selling a piece of property they don't own?
Well, if they sell a piece of property they don't own, then the person who actually has the correct title to the land,
what are they going to do?
they're going to come.
They're going to come back, right? So whenever you buy a piece of property, one of your concerns is this person actually the owner? Because if he's not, the true owner may come back in the future and be like, you're on my property, get off, right? Scram, I'm going to move to eject you. So the purpose of a general warranty deed is that the seller says, look, I'm going to put my name behind my transaction, okay? I am going to warrant or guarantee any defects in the title, right? If there are any defects in the title, right, again, the deed conveys the title, that's the relationship. If there are any defects in the title, I'll stand behind it. So if someone comes back in a couple of years and says he's a true owner, I'll compensate you for your loss. Okay? And the key point of a general warranty deed is it's not only in the present. It's not only I will insure against any defects that are here when we sign the papers, but let's say in 5 or 10 years someone else comes along and asserts another claim, I'll defend you there also. I think of the general warranty deed as like a bumper to bumper, 60,000 mile warranty, right, in a car, right? When you buy a new car, they'll give you a warranty basically for everything for like 5 years, right? Even if it's broken when you buy it, or some defect arises in a couple of years, they'll cover it, but they won't cover it forever, right? It's usually 5 years, 60,000 miles, or something like that. Because if you have a 10-year-old used car with 100,000 miles on it, at that point it's your problem. But they'll at least guarantee for stuff when you drive off the lot, and for maybe a couple of years thereafter. So think of the general warranty deed as like your bumper to bumper, full warranty, everything covered, right?
But
yeah, Bradley?
this one's covered forever, right?
Well, some defects are, some aren't, right? So the issue of the general warranty deed is if there was some sort of a defect that arises based on the original transaction, they'll cover it. But for some future things that arise, there's a period of limitations, a statute of limitations that kicks in. Which is why the analogy, I think, works. All right, Kayla, tell me about a special warranty deed, please.
So a special warranty protects the grantor. They're only like held accountable for their own love.
Yeah. So this is like, you know, when you're buying car insurance, you can protect your own car, or also you can protect the guy you hit, right? It's something like that. This says that the person giving you the warranty is only ensuring his own acts are valid. So let's say, I'll give you an easy example. You know, I sold a house to Kayla, and then Kayla sells to Philip. Kayla warranties that all of her actions are sound, but she doesn't vouch for me. So maybe I stole the property some years ago, Philip is out of luck, right? He can only sue Kayla for her damages under a special warranty deed. Now, Simone, why would someone ever not get this bumper to bumper, you know, 60,000 mile general warranty? Why would someone want something less than that?
Because of money. Like
Oh, yeah.
spend that much money.
Which is going to be cheaper?
A special warranty.
Yes, ma'am. Exactly right. The general warranty deed's expensive. It costs a lot more. As you go down the hierarchy, the cost drops. But as the cost drops, the risk increases. You're taking on more risk. The property you're buying may not be what they say it is. So that's your decision, right? Do you want to buy a guarantee with this general warranty deed, or you're going to take a gamble? Okay, Chester, finish it up. Tell me about a quitclaim deed.
A quitclaim deed has no warranty.
None. So when they buy it, what are they saying? Take it or leave it, or I'll give you a better example. When you see a used car, you ever see the sticker in the window, as is? You've all seen that. Who here bought an as is car? Oh, you guys are better off than no. I bought an as is car. Yeah, it was a piece of junk. No AC or anything. Actually, I bought the car in the winter, and I didn't do a good job testing out the thing, so I didn't realize the AC didn't work. But it hit me a few months later. Although in New York, having no AC is feasible, here it would not work very well. So the quitclaim deed is like as is. It's, look, we're giving this to you. It's going to be dirt cheap. We don't make any promises. I think there was a note in your book somewhere that said the price of the quitclaim deed is basically half the price of the general warranty deed. So if you want that guarantee, you're going to pay double. So maybe you're like a real estate speculator and you've done your homework and oh, this is a good property, I'm going to buy it. That's fine, you can do that. But the problem with that is you may be screwed. And there may be a person who holds superior title who comes along some point in the future, you don't know when it's going to be, he shows up and moves to eject you. And then you go to the seller like, look, you sold me this property. He's like, too bad, quitclaim deed. You'll often see in practice using the word quitclaim as a verb. You'll see this. Someone will say, he quitclaimed the property to me. He quitclaimed with a D, right? He quitclaimed the property to me. So you may see that in your practice or wherever you go out, but that basically means he gave it to me with no promises. He quitclaimed it to me. Okay? Yes, Anna?
When you're saying that they're more expensive and cheaper, is it something that, like, you take a piece of property and they have one of these three things?
You negotiate over it.
You get to choose one. And
Well,
more expensive.
I mean, you negotiate over it. Let's say the seller comes at you and says, look, I'm going to give you a quitclaim deed for $50,000. And then you, Anna, you say, you know what, I want a general warranty deed. Okay, fine, give me $100,000. Right? So it's something you would negotiate over. Make sense? Yeah, it's not like when you buy real estate, it's not like, you know, like Starbucks, like a Venti Grande, you know, it's not like different prices, but it's something you have to negotiate over.
So, like, even if they, say the seller, this is, I don't think this would happen, but if they knew there was a potential for a problem, they would be dumb, but they could still sell you.
Well, that may be a clue that something's up, because if the seller says, I'm going to give you a quitclaim deed, and you're like, I want a general warranty deed, and they're like, sorry,
They don't want to.
you might want to walk away at that point. Now, a lot of people who do real estate speculation, they don't care, right? they'll take the cheap thing with the hopes that no one ever shows up. And they might flip the property to someone else, and then the other person's stuck with it, right? So this is why next week we'll do what's called title searches, where you try and trace for yourself the history of your property. Don't rely on the representation of the sellers. I promise you, in this exam, which you'll take, someone will lie and say, I own this, when they do not own it. I promise you, 100%. Every exam I've ever given is the same thing, I promise you. All right. So don't be surprised. Questions on the general difference between these three categories? All right, let's go back to 615. And I want to walk you through the paragraphs of this general warranty deed. And this is pretty standard. I'll show you the Texas one. It's basically the same thing. There's not much of a difference. So it says, general warranty deed. I, John Doe, grant to Nancy Rowe. And that's, by the way, that's why it's Roe v. Wade, if you already know that. Roe was like a takeoff of Doe. It's always John Doe, so it was Jane Roe. Her actual name was Norma McCorvey. She lived in Sugar Land. She died about 6 months ago. The story is strange. She was the plaintiff in the Roe v. Wade case. She actually gave birth and gave the child up for adoption, ultimately. And she later became a born-again Christian and came out to be pro-life. And it was a very, very sad life because the pro-choice community didn't really want her anymore, but the pro-life community kind of took advantage of her, so she was happy nowhere. And she died basically alone in a nursing home, I think in Sugar Land, Arcadia, the last 6 months. Very, very sad story. Anyway, so Nancy Rowe and her heirs assigned forever for $10 and other good and valuable consideration following real estate, so you describe the land, right? You have to describe the land. To have and to hold. This is a very important phrase, to have and to hold. What does it mean? Isn't that like redundant? You have something, you're holding it. This is one of those cases where some lawyer like 500 years ago put this in a deed and a judge said, we need that language in there. And lawyers are like, uh-oh, I don't want to screw up. I'm going to keep using that language because the judge might rule against me. So you have this like accumulation of worthless languages, right? That you keep adding it because some judge 500 years ago said you needed to have it. So to have and to hold, there's a footnote about it if you jump down to the bottom of the page. It doesn't really mean anything, but it's a custom or tradition that lawyers keep. Lawyers are creatures of habit. The same way I'm teaching you, my teacher taught me, and his teacher taught him. It's a nice imagery, but you have a lot of baggage that comes with that, a lot of worthless language. So to have and to hold the premises with all the privileges and appurtenances belonging thereunto. Okay, here comes the part I actually want to talk about. This paragraph, which is not very long, lists 6 different covenants. 6 different covenants. Okay? What I want you to pay attention to is the tense of the words. No, not like tent, like you go camping. The tense. Grammar, right? There is the present tense. There is the future tense. So, I am living in this house. Okay? I will be living in this house. He is living here. He will live there. Everyone see the difference, right? As we go through these 6 covenants, I want you to understand which tense are we talking about. Okay? Before I do that, there's 2 words which I need you to understand. Grantor and grantee. Distinguishing these drives law students nuts. And I don't think I even understood how to distinguish them until I took the bar. But there was some blessed bar instructor who gave a tip. I still remember. How do you distinguish the grantor and the grantee, right? One of them is selling the property, and one of them is buying it. Which is which? I'm going to teach you this tip, which I didn't learn until I graduated, but you'll have it now. Focus on the last 2 letters, right? Because that's the only difference. You have grantor, O-R. You have grantee, E-E. When you see the E-E, think of like me, right? Remember me? That's who's receiving it, right? Whenever you see the extension E-E, that's the person who's receiving the thing, whatever it is. Or is the person giving it, right? And this is not just grantor, grantee. This is contractor, contractee, mortgagor, mortgagee, lendor, lendee. You'll see this in like 100 contexts. In when you do secure transactions next semester, right? You'll see this over and over again. So remember this. If it's EE, think of me, that's receiving it, OR, giving it. So the grantor is a person selling the property, and the grantee is a person buying. Okay? Don't get this confused. Again, if you get the terminology right, you're halfway to a B. It's not that hard. But don't confuse the grantor and the grantee, because this is how I'm going to test you on it, right? I'll say, what are the legal rights of the grantor? And if you don't know what that is, you answer the wrong question, you're in trouble. Right? I'm asking about the seller. I'm not going to say what are the seller's rights, what's the grantor's rights? So, get your terminology correct, please. Easiest stuff for you to do, get your terminology, even if you don't understand the concepts. Sound like you're competent, right? When you're taking the bar, even if you don't know the answer, put enough coherent sounding terminology that you're using it correctly, and you'll get yourself halfway there. Trust me on this. This is, little things can help you a lot, and terminology is one of them. So let's read this statement. Okay, so the grantor, that is the seller. Again, notice the document does not say the seller. Wouldn't our lives be easier if it said the seller and the buyer, the seller and the buyer? Wouldn't that be no. You're lawyers, or soon to be at least. So the grantor, the seller, that is, for himself and his heirs and assigns. That's saying it's not only him, but his people come after him. Covenant. The word covenant means promise. Right? Whenever you see covenant, just put promise in your notes. Covenants that, number one, that the grantor is lawfully seized in fee simple of the premises. Okay? That the grantor is lawfully seized in fee simple of the premises. So the first word I want you to focus on is. Is a present tense word. So what this promise is saying is, at this present moment, I, the grantor, the seller, am lawfully seized of the property fee simple. Now, why is the tense important? There are two types of covenants. There's present covenants and there's future covenants. There's a big difference between them. Future covenants can be brought up at any point. Present covenants can only be brought up at the time of the transaction or shortly thereafter within a statute of limitations. So you need to know which covenant is which. So this is a present covenant. Now, what the hell does lawfully seized mean? You remember last semester, the livery of season, where they put the little clump of dirt and the twig in their hand, right? That's what seized means. It doesn't mean like you had like a seizure, right? This is not like someone grabbed you and seized you. It means you have ownership. And not just any ownership, fee simple. And for those of you who don't recall from last semester, you should. The fee simple is the complete bundle of sticks, right? You own the entire bundle. You have complete ownership. There's no one with superior title. It's not a life estate. It's not a fee simple determinable or anything else. You have fee simple. So this first one, you put this in your notes, it's called the covenant of season. Right? This is the present covenant of season. This is the first one. Okay. Now, a lot of these are repetitive. They overlap a lot. In fact, you don't even need all of them. But the first one here, which I spell out for your book for you, is called the covenant of season. Number two, that he has, again, has is present tense, so this is a present covenant, that he has good right to convey the fee simple. This is called the covenant of the right to convey. The covenant of the right to convey. Where the grantor says that he has the right to sell the property. This is similar to the first one, but they're not exactly the same. You can imagine a case where someone has the ownership of a property but doesn't have the power to sell it. Maybe they're a trustee, right? Maybe they're holding it for someone else's benefit. So it's not always the case that someone who owns property can sell it. Any questions on that? Okay, number 3, it says that the premises are free from all encumbrances. Again, are, present tense. So this is the present covenant against encumbrances. Now, this doesn't mean like, you know, there's like a tree that fell in the backyard, right? There's something blocking, right? This refers to legal encumbrances. So example, it could be a mortgage, it could be a lien, maybe the bank has a lien on the property. It can be an easement, right? It can be a covenant. Now, can you sell a piece of property with an easement or covenant on it? Of course you can, but you have to disclose it, right? You can covenant and say, there are no encumbrances on this property except for X, Y, and Z, right? There are no encumbrances except for these 2 covenants we have. There are no encumbrances except for this mortgage which I have. So you can sell a property with the general warranty deed, noting that they have these encumbrances, but you have to disclose it. And if you fail to, that gives rise to litigation. Okay? All right. Questions on this? Bradley.
When you do disclose those encumbrances, the language would be the same, but where would you actually disclose them?
Hold on, there might have an example of that. Okay. So this is actually, I found this one online somewhere. This is a general warranty deed. By the way, warranty deed and general warranty deed are the same thing. They're basically interchangeable. So this one I found, I think it was from Brazoria County or somewhere, that says, okay. It's basically a general warranty deed, but has the subject, however, to the following, right? And it says, for example, any oil or gas minerals, etc., are reserved, any easements or whatever, right? So you put these 2 paragraphs here that says, this is a general warranty deed except to these other encumbrances. So you list them right up there. Questions? Okay? So I think I'm up to 3, right? Okay, let's do 4. Oh, I'm sorry, before I get to 4. The important point to stress about a present covenant is they can only be broken at the time of the conveyance, right? These covenants can only be broken at the time of the conveyance. And think about it, right? Look at all 3 of these. Do you lawfully own it? Well, you either own it or you don't. And the time to raise that is when the transaction occurs. Do you have the right to convey it? You either have it or you don't. Are there encumbrances? There are encumbrances or there are not. So with the present covenants, you have to raise these at the time of the transaction or within a statute of limitations. You can't wait forever. Okay? You have to raise it within a certain time after you do the transaction. And that varies, and it could be 5 years, it could be 10 years, whatever the jurisdiction allows. Okay, any questions? Yes, Justin.
You said only 1 through 3 are the covenants that are broken at the time of conveyance, or all of them?
Yes.
Just
The present covenants have to be violated at the time of the transaction, right? Because think about it. If you don't own it, you're not going to suddenly own it 15 years later, right? If there's an encumbrance, that encumbrance doesn't magically vanish 15 years later. All these first 3 are problems that arise at the time of the transaction. Okay? Everyone with me? Alright, let's go on to the future covenants. And I'm lecturing a bit, but I think this is actually more useful because they're a little counterintuitive. The future covenants are different. These are covenants that cannot be breached until some future event occurs. With a future covenant, it can't be breached until a future event occurs. Right? These aren't breached at the time of the transaction. So how do you know if you have a future covenant? Again, grammar. You look at the tenses of the words. Will, right? Each of these has the word will in it. I will do this, I will do that, right? What happens in the future, so you know it's a future covenant. Again, don't mix this up. If you see a present tense versus a future tense, you know the answer. It's your your cheat sheet, so to speak. So let me read number 4. That the grantor and his heirs and assigns will forever warrant and defend. Now, notice what it says. It's not just the grantor, it's the grantor's heirs and assigns. So the grantor's saying, I'm only binding myself. I'm binding my kids and my grandkids. Sucks for them, right? If they want my property, they have to take these responsibilities. Right, by the way, if any of you ever inherit property, you're not just inheriting the property, you're also inheriting whatever claims that your grandfather made. So there's sometimes a disadvantage to accepting someone's interests. Just food for thought. You may not want it. It may not be worth your time. You may have no idea what the hell they're talking about. Grandpa made a bad deal somewhere, right? Not a good idea. So the grantor and his heirs and assigns will forever warrant and defend the grantee and her heirs. So not only are you promising to defend the person you're selling to, the grantee, but also the grantee's heirs. So this goes all the way down for years and years and years. So the grantor and his heirs and assigns will forever warrant and defend the grantee and her heirs and assigns against every person lawfully claiming the premises or any parts thereof. That's the important part, right? Against any person lawfully claiming the premises or the parts thereof. This is what's called the covenant of general warranty. The covenant of general warranty. And you're defending against future claims against the land. And what does that actually mean? If someone shows up and says, that's actually mine, you get a refund of the purchase price. That's a big deal, right? That's a really big deal. You get the purchase price back. What's your loss? Now, if you happen to maybe have sold it and somewhere else in the medium, it may not be that much, but you're compensated for your losses. So there's a very big risk when you hand out a general warranty deed if you don't actually have it. Because then your great-grandchildren maybe have to go defend against this sort of assertion. Any questions on number 4? Yes, Bradley.
So, if I sell property to you, right, my heirs gotta, protect your interests if somebody comes back. Right?
Yeah, crazy, right?
But if you then sell it to somebody else, my heirs are free and clear.
Well, no. If I sell it to someone else, right, what's going to happen? That person sues me, and I come back to your grandkids, right? That's the difference between the, the general warranty deed and the special warranty deed, right? The general warranty deed basically says, look, I'm guaranteeing it not just against you, the grantee, but your grantee and your assigns. So if the grantee assigns it to a third party, that third party can then go back to the original, right? With a special warranty deed, you limit your exposure to the single person. But by putting here the grantee, her heirs, and her assigns, it goes all the way down. So this is basically saying, I promise to defend this against anyone, anywhere, anytime, and if it's not me, my grandkids will do it. Which is a weird thing, right? To say like you're binding your poor grandchildren to this claim they probably have no idea about, but that's how property works. I had a student here a couple of years ago he was in his 50s, and his grandfather had owned some property out in West Texas and had no will, and he died, and no one really cared about it until they discovered oil, and then they cared about it, and then they recognized that there were like almost 40 or 50 heirs at that point, because there were all these kids, the grandkids, the nieces and nephews, right? There was no will. And there was this massive fight to try and divide it up, and these things never work out well. But when you say your heirs and your assigns, that means all the heirs, everyone, not just children and everyone, heirs. That's why you should have a will. I don't have a will. I probably should. I don't own any property yet, but I'll get around to it. That's number 4. Number 5. The grantor and his heirs and assigns will guarantee the quiet enjoyment of the premise to the grantee and her heirs and assigns. Okay? This is what's known as a future covenant of quiet enjoyment. The future covenant of quiet enjoyment. Okay? This is similar to number 4, but it's a little bit more specific. It means that you promise the person won't be disturbed in their possession and enjoyment by someone asserting superior title. It's a little bit more specific. Basically, it doesn't mean you have the right to be quiet with not a lot of noise. It means no one comes in there and asserts they have a better title than you. Number 4 and 5 are really similar. You're going to ask me, Josh, what's the difference? I'll say not much. They're both future covenants. You can probably sue under one or the other, so it doesn't really make much of a difference. Questions on that number 5? Yeah, Yusuf?
How do you promise them that they won't be disturbed by someone coming with better superior title?
Well, there's an easy way. How would you promise that? How can you be sure no one will ever come in with a superior title?
There's no one with better title.
Yeah, exactly. Yeah. How do you promise and no one with a better title will show up? Make sure there's no one with a better title. Right? That's the easiest way. If there's no one with a better title, you have nothing to worry about. Now, if you know someone has a better title, you'd be an idiot to write a general warranty deed. You just wouldn't do it. You give a quitclaim. Okay, let's do the last one. Wrap up. Number 6. That the grantor and his heirs will, on demand of the grantee or her heirs or assigns, execute any instrument necessary for the further assurance of the title, the premises that may be reasonably required. Okay? This is what's called the future covenant of future assurances. The future covenant of further assurances. The future covenant of further assurances. That is, the grantor, the seller, will sign any documents needed to perfect the title. Let's say, for example, someone comes along in the future and says, that's really mine, and you have to go to court and you have to get the grantor to sign something. Here the grantor says, look, I'll take care of it. I'm not going to, be a jerk. I'll sign whatever you need. Okay? Now, the important point about the future covenants is that there's a statute of limitation that works differently. With a future covenant, the statute of limitation begins to run when the covenant is broken, right? With a future covenant, the statute of limitation begins to run when the covenant is broken. And here's the important point. It's not broken until someone shows up and bothers you. It isn't broken until someone comes up and says, hey, that's mine, I'm going to sue you. That's when the covenant's broken, and that's when the clock starts ticking. If there is merely a person who has superior title, and they haven't brought any lawsuit against you, you can't sue under a future covenant, because they haven't sued you yet. The time to sue someone with superior title is earlier, with the present covenant. But if you wait too long, you're in a tough spot, right? If you don't sue right away to get rid of a person with superior title, you basically have to wait to be sued. And only when you're sued, then you can go back to the future covenant, right? That's the issue in the first case, the Brown versus Lober case, right? Depending when you bring the suit, you can rely on either a present covenant or a future covenant. With a present covenant, you have maybe a couple years after the transaction closes. If not, you have to wait. And there's something of an unfair aspect to that, right? Because if you find out maybe 15 years later that there's some superior owner, you have to really sit there and wait to be sued. That's not a good way of living your life. But that's why the burden is on you to do your homework before you buy the property, not 10 years later. All right. Questions on number one, on the present and future covenants? Yes, Robert?
For the future covenant, the statute of limitations starts when the person with better title starts their.
It's when the covenant's breached, which generally means when the person with superior title shows up and says, I'm gonna sue you. And I mean, there's even debate, is a threat enough? Like, what if the guy says, you should leave? Is that enough to breach the covenant? Probably, I think that's probably enough. But you gotta take some sort of action. Sorry. Yeah, Justin.
Why is it not enough that they breached it whenever you find out someone has superior title? Because the prior owner is asserting that he had the highest title and he's giving it to you. So
Well, you
find
could have
out,
brought that though right away. Why'd you wait? The thinking here is you should have brought it right away. You failed to do it. That way you have to sit around and wait until you get sued, right? The law doesn't like people who sit on the remedies. And if it was discoverable that someone else had a superior title, you should have done that discovery much earlier.
But it seems like they're sitting on the remedies once you find out that someone does have better title. You can't do anything until they come.
Well, because your covenant's not been breached, right? Look at how these covenants are phrased. Okay? That the grantor promises the quiet enjoyment of the premise. Is the mere existence of superior title disturbing your quiet premise, your quiet enjoyment? Right, that's what. The mere existence of a superior title doesn't disturb your quiet enjoyment. It might make you very nervous, right? And antsy, but it doesn't disturb you, legally speaking. Until you're disturbed, you can't sue.
Sorry. So if you know about someone who does have a better title than you, but they haven't done anything to assert a claim against you in the land, if you go to sell that property, do you have a duty to disclose?
Well, you can do other stuff, right? You can go to a court and ask the court to declare quiet title.
Okay.
And quiet title basically means you're asking the court to assert who owns it. Right? And then if the court says, you know, this person doesn't own it, that might be enough to then try and sue in the general warranty deed. But generally speaking, you may not want to risk it because you may know you're going to lose, right? If the person actually has superior title and you bring this lawsuit, you just like make yourself homeless. So it's a gamble, right? It's a gamble when you buy these properties and you don't do a title search. All right, let's do the first case. Who am I up to? Yes, sir. Walker. All right, give me the facts, please, in Brown versus Wilbur.
Okay, so the boss owned 1/3 interest in the mineral rights and parcel of land. They conveyed that to the Browns, who thought that they had the entire interest in the mineral rights. So they go to negotiate a deal to sell their mineral rights when they discover that they only have 1/3. So they end up suing. The executor of the boss' estate for a breach of the covenant of quiet enjoyment.
Good. Okay, very good. Thank you. So this is a case from Illinois, but it could just as well be a case here in Texas, right? So there was some 80 acres that were sold, but the owner reserved a 2/3 interest in the mineral rights. And what that basically means is if the land ever yields oil, coal, whatever it is, and it becomes valuable, he gets 2/3 of the profits from the sale of those minerals. However, the Bosts, some years later, conveyed the property to Brown with a general warranty deed, just like this. And there was no exceptions, right? I think I showed you the Texas one a minute ago. The Texas one has these subject to, however, reservation of mineral rights, right? This is why it's in there. Because you recognize sometimes you're selling land and you're not guaranteeing all the stuff underneath it. Okay? So the Browns took it and they weren't aware that this reservation was present. Some 20 years later, they found that there was coal. And they sold their mineral rights to a coal company. The coal company, though, did their homework, right? They did a title search and they recognized that this original owner has a reservation of a 2/3 interest. So they said, okay, Browns, we will cut down the amount of money we're giving you. Instead of giving you $6,000, we'll give you $2,000, right? Only a third. At that point, the Browns sued the Bosts for $4,000. The difference, right? And they sued on the covenant of quiet enjoyment. Right? They're suing the covenant of quiet enjoyment. Yusuf, you're next. Why do you think they chose the covenant of quiet enjoyment? Why did they use that covenant? They have all these other potential ones to use.
Why did they pick that covenant?
Yeah.
Not sure. Maybe.
Well, tell me again, Yusuf, what is the covenant of quiet enjoyment? How did we define it a couple minutes ago?
That you're promising that no one with better title will come.
Okay, good. The key point is no one tries to disturb you, right? Has anyone here tried to disturb the Browns?
Not yet.
Not yet. Right? Who would be the person to disturb the Browns, if anyone would do it?
The original.
Yeah, right? The original guy, I don't think he's even named, right? But the original owner who reserved the interest. That hasn't happened yet. So again, you said, why then would they sue under this covenant of quiet enjoyment if their enjoyment hasn't been disturbed? What were they trying to do here? The lawyers here weren't stupid. I mean, they lost, but they weren't stupid. They were trying to do something very specific.
Were they trying to get the other company to sue them?
No. Thomas?
Were the lawyers trying to get, like basically evict the original owner out of their 2/3 since they weren't exercising?
No, the original owner wasn't party to litigation. Jared?
They were trying to cover up the fact that the plaintiffs never did a proper title search in the first place.
And as a result, what did they blow? What did they miss?
The covenant of safety.
And when would they have brought the covenant of season? When
They bought the property.
Because what kind of covenant is it? Present. And then what happens when you wait too long? What do you blow? What do you call that thing when you wait too long? Thank you, Sal. Yes, okay. So here's the problem, right? The correct covenant to bring was the first one, the covenant of season. That the grantor is lawfully seized in fee simple. He didn't have fee simple. There was a 2/3 reserved mineral interest. So the correct thing for the Browns to have done was to bring suit at the time they bought it or shortly thereafter, saying that they breached this present covenant of season. And how they did so, they would have prevailed, right? Right? The boss sold land with a general warranty deed, and they didn't have fee simple. There was someone else with a 2/3 reserved interest. But the problem is they waited more than 10 years. And by waiting 10 years, they blew the statute of limitations on the present covenants. And when you blow the statute of limitations on present covenants, you get creative. So his lawyer said, okay, we realize that we're time barred. We can't bring suit under the present covenants. So we'll just pick one of these other three, number 4 through 6, right? We'll pick one of the future covenants. But the problem there is that the future covenant only comes into effect when it's breached. I think Yusuf said it a minute ago correctly. It's only breached when they're disturbed, when someone asserts a superior claim. And because there had not yet been a breach of contract, a breach of the deed, the suit was premature. So until the original owner shows up and says, I want my money, or I want my interest in the coal, there's nothing to be done. Bradley.
Is the attorney therefore opening himself up to malpractice?
I mean, it's a good question. My guess is not. The attorney who would probably be open to malpractice is the one who didn't perform a title search when they bought it. I think that person screwed up. And if they had title insurance, they could probably sue on that. I think here the lawyer was trying to be creative. He put forward an argument that was wrong, but had some merit to it. But I think this lawyer was trying to make the best of a bad situation. I mean, because look, you're gonna have clients come to you and you say, look, dude, you blew the statute of limitations. Let's think of ways of getting around it, right? It's not an insane argument. I mean, there's some merit here. So I think the person who screwed up was the original title company. Maybe they do a title search. I don't know. So the court recognizes, right, that the plaintiff here is simply trying to extend the protections of a present covenant to the future. And they can't do that. Without a disturbance, the future covenant is not breached. The problem is that the plaintiff failed to bring the action within a 10-year statute of limitations. They probably didn't do a title insurance check. This is a matter of public record. The coal company figured it out pretty easily. So when you're lazy and you don't do the correct work, the courts will against you. Okay. So right, the rule here, the Rollin Brown, is that with a future covenant, you can only sue on it when it's breached. And unless someone disturbs you, too bad. The time to have brought this suit was with the present covenant within 10 years of the sale date.
So future covenants, you're generally dealing with standing.
Do you mean standing in the constitutional sense?
As in, you have to have a claim.
You have to be injured.
Just not the
Yeah, you have to be injured. There has to be some sort of concrete injury you suffered. So if you're thinking in terms of Article 3 standing, that's maybe one way of looking at it. But you have to be bothered. Someone has to bother you about it. The original owner has to show up and say something to you. Yes, Hanan.
Could they, have brought it up again, like say it did come up?
Well, if the original owner showed up and said, I want my coal money, they could have, right? But the coal company, if I had to guess what happened, the coal company found the original owner and said, we're going to pay you. And it's like, okay, right? That's the problem. Originally the coal company said we have 6,000 total. They said, oh, okay, we'll give you 2, and they probably found 4 for the original guy who had wanted nothing to do with this case, right? Didn't care less. Right? If you're a coal company, you're not that stupid, right? I had a student a couple of years ago, and she worked for an oil company, and her job was to like trace back the various grants of land going back to like the Louisiana Purchase, right? All the way back to the 1800s. And the reason why is if you're having a multi-million-dollar reserve of oil or gas, you don't want some random person showing up and saying, hey, my great-great-great-great-great-great-grandfather has this piece of paper, give me $1 million, right? You want to figure out in advance who gets what. Chester?
But that doesn't really benefit the coal company, the same they get from
They don't get sued, right? They know in advance who's getting what, because let's say they're drilling oil in a piece of property and they forgot some distant relative. They're not only on the hook for the price of the oil, but a trespass claim as well. And that can be expensive. So it's far better to get a license in advance than to wait and get sued for trespass. Because when you're you did this last term, I think when you're drilling on someone's land and someone has a reserved interest, you're committing a trespass. And that's a tort, and you can get a lot of damages for that. Especially if the oil company knew the guy had it and drilled anyway. What's that movie, There Will Be Blood? You want to see that movie? Sick movie, right? But that's the general idea. You can't do this unless you have the permissions. All right, any other questions on the Brown case? All right, let's do the next case from Connecticut. Let's see, we got Jonathan. Okay, give me the facts of the Frimberger, the Connecticut case.
In this case, there was a dispute. Well, it was a brother, and they subdivided a piece of property. The main dispute was the title marshland. There was
A swamp, basically, right?
Wherever they subdivided it, whenever they subdivided, put the property on there, where he put the bulkhead was.
What's the bulkhead?
I believe what they put on the edge.
Right. So what did they put into the swamp?
To keep the water out, cleaning out the property.
Okay. So this is they filled the swamp with cement. What we call today wetlands, we used to be called swamps, but basically you drain the swamp, right? You never had that problem before. You put concrete into the wetland so they can build on it, right? You can't build on a piece of wetland because the ground shifts underneath you. So if you want to build like a deck or a patio or something near your shoreline, you fill bulkhead with concrete or something else. Now, Jonathan, what was the problem with filling concrete or whatever else with bulkhead into this wetland?
Whenever they did it, they did it over the title. Basically, they violated the lines of the marshland.
Are you allowed to dump cement into a wetland in Connecticut? No, you're not. So I think at this point, at least, every state in the union has fairly strict regulations concerning the protection of wetlands, which again are swamps, as they used to be called. And you're not allowed to destroy them. And putting concrete into it is basically destroying habitat for wildlife and other creatures of nature. The guy who filled in the wetlands transferred the property by quitclaim deed, right? But then the person who got it sold it again by a general warranty deed. Virginia, do you think there's something problematic if someone gives you a piece of property with a quitclaim deed and then you flip it around to general warranty? Do you think there's something like,
Yeah.
what's maybe not a good idea about that?
Well, the quitclaim means you have a warranty, so there might be something fishy about the
Yeah.
land that you got. But then if you put a general warranty on it, that means you're saying, like, I
Yeah.
stand by the land that I'm giving you. It's just, I just don't think that's a good idea.
Right, so we have a situation here where there was first a transaction in 1984 with a quitclaim deed, which is like, look, you're taking at your own risk. And then the following year, there was another transaction, and there was a general warranty deed. And there was a provision in the general warranty deed, I want to read this to you. It says, we covenant that it's free and clear of all encumbrances, but subject to building and zoning restrictions. That is, it's free and clear of all encumbrances, but subject to building and zoning restrictions. Lauren, what does that mean? What does that language mean?
Well, that although it's free and clear from anybody else having ownership or title of it, you still have to accommodate for zoning restrictions or whatever laws that the area may have. Or
Now, is that only saying that this may be subject to restrictions, or that it may in fact be in violation of the restrictions? What's it promising against? Is it merely saying that, look, there's some zoning laws in Connecticut, there's zoning laws everywhere? Or is it saying, you're taking this even if there are violations of the law?
I would say if they're giving a warranty deed, then I would think they thought that it wasn't any violation, and but they're saying, just in case there is, you're subject to it.
Now, do you remember we did a case before the break from Kansas, Lohmeyer? Remember that case? That was the case where a house was sold, and there was an ordinance that said the house had to be, was it 2 stories, was only 1 story, right? And the ordinance said you have to have a certain amount of feet between the sidewalk and the front of the house. And they sued under the contract of sale. And they said, look, you sold this to us in violation of the contract of sale. And do you remember what the court held there? Yeah, it wasn't marketable, exactly right. The court said that the contract of sale was not marketable. The title was not marketable because it was in violation of a zoning law, right? It wasn't the mere fact that a zoning law existed that it was in violation of it. Remember that? This case, though, is something different. And let me explain the distinction. The case Kaylee mentioned a minute ago is exactly correct, was a suit on the contract of sale. This is a suit on the deed. Oh, remember I said there's a difference, right? I think it was a Kansas case, or maybe Oklahoma, I can't remember. But the Lohmeyer case involved a breach of the contract of sale. And they said, you can sue on that because you didn't tell us there were any violations of this zoning ordinance. But here it's a violation of the deed. Now, I don't think that distinction is actually persuasive, but that's a distinction I'll give you. Right? So Justin, did the fact that the land was in violation of these environmental regulations breach this covenant? What did the court hold?
No,
Why not?
because there was no imminent, well, because it made the title, it talked about the title being unelectable.
Is the title fine here? So the court says?
Yeah.
The title's fine here, the court says. Right? But they're in violation of the law, aren't they? Well, are they?
Well, they said there's no imminent threat that
What would you mean something imminent threat? Give me more.
the government hasn't actually pursued.
Yes. So they're basically saying, look, you may think you're in violation of the law, but until the government comes down on you, you're fine. Does anyone find that reassuring? Right? So this is not, you have to wait to be sued. It's, you have to wait to be arrested. Maybe not arrested, might be exaggerated. We have to wait to be fined, right, by the state. So here, right, it's true that there was misrepresentation, right? But the warranty as phrased doesn't allow any sort of lawsuit until the government actually comes down on you and threatens you. That is, the mere existence of a regulation violation, the mere existence of a violation of this environmental law isn't enough. You need more. Now again, I think this case is in contrast with the Lohmeyer case from Kansas. I think their intention. Again, you have Kansas and you have Connecticut, different worlds, right? Courts don't always agree. But here, they're saying that you can sell the property, and it's totally marketable. And perhaps there's a couple of reasons why I think this holding makes sense. If you want to do a title search, you can find out if someone has a superior title. But how do you determine, Elena, how are you supposed to determine if your property has environmental problems? What do you have to actually do to make that conclusion?
Well, you can do a land survey.
Yeah, and not just a land survey. There's a special environmental survey they mentioned. It seems very difficult, right? And that's generally not something that can be done when you're looking around to buy a house. It's still going to take a couple of years to set up. So even though you can't readily discern it, you're still on the hook. So the bottom line of this case is, even though they sold it with a general warranty deed, and even though there were environmental violations on the property, the covenant was not breached because the government hadn't come down on them yet. Indeed, they didn't even submit any sort of appeal to the government. They could request an extension or whatever. No. We all know that was going to be denied. If you filled a wetland in Connecticut, you're screwed, right? You're going to have to pay a lot of money to fix that, and it might not be fixable. But here, the seller got off scot-free, and the buyer had no idea, and took a general warranty deed, is on the hook. Now, this is Virginia's point a minute ago. If the seller had done his homework, if the buyer had done his homework, he would have recognized that the guy beforehand gave a quitclaim. And that should have been a symbol that, they only got a quitclaim, maybe something's off. But he bought it anyway. So I think the fault here, it falls to the buyer. Not entirely fair, but I think he does bear some of the blame here. Okay? So basically, the court holds that latent conditions in violation of a statute is not an encumbrance. Therefore, the covenant was not violated. Therefore, there's no remedy for the buyers. Questions on on the second case? Yusuf?
Like if you do a survey like that and you see previous owners all gave a general warranty deed, and then who you're buying from is trying to give you a quick claim or trying to go,
you get nervous.
Is that like a red flag?
Yeah, you get nervous. Especially if it's land on the shore. Owning beachfront property is not a joke. I think people in Galveston know that well. But there are so many more possible environmental issues when you're on the shore that you have to be aware of. Owning waterfront property is a lot harder than if you have a regular property.
Well, it was also just like how they did a quitclaim deed, but when he got the quitclaim deed, it was from his brother.
Yeah, they were flipping it, yeah.
So, I mean, would that still be a red flag in family to family?
I think so, yeah. Because the brother may have been happy taking it because he knew about the damage and the share. See, the reason why this problem arose was because the buyer tried to do the right thing, right? He tried to apply for a permitting, he tried to get an inspection. If he just built his deck, no one would have noticed. So here again, honesty is punished. Like, he tried to do the right thing, and then he got screwed. If he had never said anything, he'd probably been fine. No one would have known. I don't know. All right, so another hand, Anthony.
I was a little bit, so when the owner conveyed the property under general deed, and he said that he's covenant, there's no encumbrances except for government regulations. So the court said that because they haven't been encumbered yet,
Yes.
they're good. Later on, if the government did come
Well,
in
that was actually
and
my
they
next question,
sued
right?
later,
What happens if the minute after this case is resolved, the Department of Environmental Protection comes in and says we have to shut down your house?
it would still be thrown out, right? Because they
Well,
put it
then-
in the general warranty. deed.
Well, then, if it's violated under this holding, it's a different story, right? If the government actually comes down and says you have to get off, we're going to fine you, then you go to the covenant.
Right, but the covenant said that it was subject to environmental, so wouldn't the original owner still prevail?
No. What the court held is you can be subject to regulations, right? That's fine. But there's a violation. When the violation occurs, you can sue. And the violation only occurs when the government comes down on you. Understand the difference?
That wasn't my question was, when they do come down,
Right.
and he tries to sue the owner,
You can do that.
the original owner, I know we can do it, but the original owner would say, I put in the encumbrances that it was subject to regulation. and still
But the
prevail.
court's holding here is to the contrary. What the court holds here is the mere fact that you're subject to regulation doesn't make it encumbered. What makes it encumbered is a violation, and the government comes down on you.
Yeah.
Got it?
Yeah, that part I had already gotten, but never mind.
No, try it. If you don't know.
No, after this case is done,
Yeah.
the city comes in and says, okay, we're taking this property away from you.
Yeah.
Subject to government.
Then it's not just the existence of a regulation, but the violation of the regulation.
And they go to court.
And they go to court and they sue under the covenant. That's fine. That works.
Okay. So do they win is the question.
Yeah, they win. I think they win. I think they win because it's no longer latent, right? It's a real threat. There's actually a threat of eviction. Someone has disturbed you.
Even though he put in the warranty that it's subject to the regulation.
But not violation.
No.
The difference is there's an existence of a regulation and there's a violation of the regulation. The mere existence of the regulation is not enough to trigger the future covenant. The violation of that triggers the future covenant. Got it?
Yeah, I think so.
We would have had to disclose that there was a violation and say that.
Well, whoa. But if you disclose there's a violation, who in the right mind would buy it?
Yeah.
Exactly. See, that's the point. How do you disclose that there's, oh, by the way, I filled my backyard with cement, right? No one would buy it. And that'd be the end of the story. It's like, oh, there are some coastal regulations that are in effect. Oh, no kidding. I know there are, right? There always are. But, oh, and I filled my backyard with cement. Here. No one would buy that. It's stupid. Huh?
But, I mean, is it not even a violation enough?
It's the prosecution, right?
Yeah.
And when I say violation, it's when the government comes down on you. That's what breaches the covenant. Because it's like, if a tree falls in a forest, Anthony, one at a time, please. When a tree falls in the forest, they won't hear it, right? The mere fact that you're breaking the law doesn't matter until you get arrested, right? Until you're actually fined by the government, that's when the covenant's breached. Because the covenant, the law is being broken every day that cement is there. But until the government does something about it, it's not a breach of that covenant. Anthony, you still seem perplexed.
I am, but I'll figure it out.
Okay, you can ask me afterwards.
Sure.
All right, anything else? Okay, let's go to the third case. The third case involves the concept of delivery. And you probably remember delivery from gifts. Remember, it's for a gift to be effective, you have to have intent and delivery, right? And acceptance. And generally, when it's delivered, you presume acceptance, but not always. The action handles the same way for deeds. This dates back again to delivery season. When you want to transfer property, you give them the clump of dirt. We don't use clumps of dirt anymore, but we use keys, or we use a deed or something to symbolize the clump of dirt. It's the same concept. But what often happens is that people selling property don't want to give away the deed right away. And the Rosengrant case is a good example of it. So the setup is this. Once you give someone the deed, it's theirs. And they can evict you. And they can kick you out. So very often people try and do is say, okay, I'm going to give you this at some point in the future. That way I can keep living here. But at some point in the future, it'll be yours. The problem is, if you say, I want you to have this after I die, that is what's called a testamentary gift. Testamentary. Testamentary means it's after death. And in order to give a testamentary gift, you have to comply with the statute of wills. Statute of wills, this should sound familiar. And one of the requirements of the statute of wills is you need signatures of 2 witnesses. With a deed, you don't need any witnesses at all. But you have this signature requirement to prevent fraud. To prevent fraud. Because once you're dead, you can't defend yourself in court. You're gone. So the Rosengrant case is a situation where you have this cute elderly couple that wanted to help out, you know, this guy taking care of them, but they didn't really want to help him quite that much. So they did something a little funky. Tell me, what did the elder Rosengrants do that's a little bit quirky?
They created a will.
No, they did not create a will. That's an important point. What did they actually do?
I guess they told the.
Well, walk me through what happened. Walk me through the transaction.
Okay, so Harold and Mildred were an elderly couple, but Harold started getting sick.
Right.
So they were trying to decide what to do with their property.
Good.
So they started meeting with a banker. I don't know. They put their deed in an envelope and all this stuff and told the banker that when they both died to give it. I don't know. I'm not 100% sure.
Lindsay?
Are you talking about how it like the uncle gave it to his nephew, and then the nephew gave it to the banker?
Good. And what did the banker do with it?
And then the banker kept it. And
Kept it where? Okay. So here's what happened, right? And I think you can all like sympathize with this. So you have this old couple. They have lots of kids. They're all ingrates, right? only one person's helping them, the entire family. And like, look, we want to thank you for helping take care of us during our lives. When something happens to us, death, right? We want you to have the farm. Now, they could have done this in a very simple way, right? Lindsay, what's the easiest way for the aunt and uncle to have just taken care of this and not have any problems?
just giving it to him and let him keep it?
Yeah. Why didn't the aunt and uncle just give it to the nephew right away and dump it?
They didn't want him to have the land until they actually died.
Why not? Keep going. What's the risk of giving to him right now?
Because then he could take the land and they get kicked off the
Evict him.
land.
Yeah. So, once he has the property, he doesn't need them anymore. For all we know, he was being nice to them because he wanted the property. I mean, it's not unheard of, right?
He did sue for it.
Yeah. It's not unheard of that children are very nice to their elders because they want to be enriched after death. It's not unheard of, right? It's a long-standing aspect of human nature that when someone's about to die, perhaps you're showing kindness because you want to get their money when they die. Okay. The aunt and uncle weren't dumb. And they recognized that once they hand over the deed, it's not theirs anymore. So they came up with this convoluted system where they said, we're going to give you this deed now. I'm going to hand it to you. You're going to hand it back to the banker. And the banker's going to keep it in an envelope. And once both of us die, the aunt and the uncle, you go to the banker, and then you pick up this envelope and it's yours. And that way, you don't have to deal with the statute of wills. You can skip the probate process, and all these other ingrate nieces and nephews don't get to be involved. Oh, they'd be involved anyway, right? If you notice, they're the ones who sued. Why is it Rosengrant versus Rosengrant? Because the nephew got sued by all his family members who wanted to share in the house as well. So, the family matters, I suppose. Indeed, the uncle died, the aunt died, very sad. And then Jay shows up to the bank, like, hey, give him my envelope, right? Give me my paper, it's mine. And then he gets sued by the other people in his family, saying that the deed was never delivered. So Megan, what does the court hold here?
They hold that it was an invalid, that it failed to be a valid conveyance.
It was not a valid delivery, that's right. Why was the delivery not valid?
it couldn't be a valid delivery of the property because even though he took the deed, he never actually took the property.
Well, did he actually take the deed though? Let's be precise.
Well, he took the deed in his hand, then gave it back to the banker and left it.
But did he actually accept it?
The deed?
Yeah. Was it his and his alone?
No,
Oh.
the bill was still on the envelope.
Oh, okay, good. Tell me the other bit. What about the names in the envelope? Tell me about that.
Both of them could come to the
Yes,
bank and remove
and
it.
here's the important point, right? On the envelope at the bank, two names are written. The uncle's name and the nephew's name. And the court says that means that either of them could have come picked it up. See, the uncle was no fool. He knew what he was doing, right? The uncle knew that so long as his name was on it, he couldn't be screwed over. He could take it back if he wanted. But by reserving the right for the uncle to take it back, that means it was not a delivered gift to the nephew. And the nephew never got it because the uncle could pick it up. Now, had the nephew taken it during life and gone and put his name on it and recorded it, he could have kicked out his uncle. He didn't. He was a good guy. And once again, good guys finish last, right? So by being the good nephew and taking care of his poor aunt and uncle, taking him down to Mexico to get treatment, doing all these nice things, he got screwed. And he lost because there was no valid delivery. Now, there's reason to suspect, if you read the concurring opinion, that the facts didn't happen as they say, because who was alone in the banker's office? Right, you had the uncle, dead. You had the aunt, dead. You had the banker, dead. And the only person left is Jay, the nephew. And if you read that, that transcript, right, it seems very convenient, right, and very conducive. So I don't think the concurring judge, Judge Breitmeyer, gives a lot of weight to this story. And so I think the only evidence that actually matters is the fact that the envelope itself did not have its evidence. And this is why the statute of wills requires witnesses. Because you don't believe this person. Oh yeah, my uncle said this and this. You're full of it, right? So when you have two witnesses who are there, they can verify the accuracy. Hopefully they're still alive, maybe not. But here, the only person who was in the room where it happened, as it were, is the guy claiming to be the owner of the property. And I don't think the court gives much to that. So, at the bottom line, because the uncle could retrieve it at any time, there was no delivery, and because there was no delivery, there was no gift. There was no conveyance of property. And as a result, the uncle still owned it when he died, and then the property must go through the probate process and divide it up. Questions? Questions on the third case? All right, so let me summarize a bit, if I can. The importance of today's lecture focuses on the present and future covenants. And you should always look at them. And they won't always be phrased exactly like this, but what you have to remember is there are tenses. And if it's a present covenant, it's using the present tense. And if it's a future covenant, it jumps to the future tense. If it's a present covenant, you have to sue right away within a statute of limitations. With a future covenant, you can only sue when it's breached, which is at some point in the future. You can't mix them up. But even with the covenants, it's not always clear whether they're violated. So for example, in the Connecticut case, the mere fact that the wetland was filled and you were in violation of the law didn't breach the covenant because the government had not enforced it yet. Okay? And then we get to our third and final case. The mere fact that you give a general warranty deed does not mean that you have a, that you actually have a valid conveyance if there's no delivery. Okay? Any questions? No? I will see you all next week. Thank you.